through their parent or through other family member and automatically are a citizen, and they want verification documents of that from the government. So once those types of papers are pending, and it's been pending for, again, there's no specific amount of time, but I would say that if you've had something pending for at least 6 months, you should at least go talk to a lawyer. Find out if that is reasonable, find out if you should be waiting that long, and find out if that is reasonable, what is not reasonable. When should you start to be concerned? When should you start to talk to that lawyer about maybe filing a mandamus?
So this is where really a client would really need to come in to Reeves and ask your expert opinion on the time, especially you would be able to look at the case and say, yes, this has gone, they are taking too long, and we recommend that you do file this.
That's absolutely true. There really is no way for someone who is not a lawyer to make a decision on whether or not it is an unreasonable amount of time. Anyone who's waiting is going to feel that anything is unreasonable, and that makes sense. But that isn't what a federal court judge is going to look at.
Right.
And for the same reason, a lawyer who's not used to doing federal court work isn't going to necessarily be the best source of explaining that this is or is not a reasonable amount of time. And as I said, at Reeves, we do many, many types of mandamus cases. We're in federal court all the time. We know what the judges are looking for. We know what they will believe is reasonable or unreasonable, and we can advise the client accordingly.
Okay. Are there any other types of cases that are filed in, let's say, a district court?
Yes, there are. Sometimes the agency, in this case Citizenship and Immigration Services or Immigrations and Customs Enforcement, make decisions on cases, on applications that are incorrect, and they do this as a pattern. You see it repeatedly in cases, and what you want to do then is go into district court to get a federal court judge to make a decision on what the law really means. That type of case is called declaratory relief. Now, in the mandamus case, essentially, as I said, you're just asking the judge to make an order saying, make a decision in 30 days.
Right.
And I don't care what the decision is, make a decision. And you will take it from there. In declaratory relief, you are asking the judge to actually decide what the law is. It's a complicated procedure. It could very well involve very lengthy motions. It could potentially involve trials. It is essential to have a lawyer who is familiar with federal court, with district court, and for that reason, it's very important to choose your lawyer carefully. At Reeves, we do declaratory relief actions on a regular basis. Not all lawyers do. There are lawyers who have spent their whole lifetime never going into district court, never going to federal court, and you want somebody who knows what they're doing in district court. You want somebody who's familiar with the courts. You want someone who's familiar with the judges. And in our office, we've been in district courts throughout the country. We're there regularly. We know the judges. They know us.
Are there any other types of cases in, let's say, federal court then?
Yes, there are. And actually, while we're still in district court, there's something called a habeas petition.
Oh, okay.
And that's when someone is being held in custody unlawfully. And that is a very, very complicated procedure because the law has changed drastically over the course of the last several years. The types of cases that the judges can even look at, where they can make a decision, and the types of decisions that they can make have been limited, have been changed over the course of the years. Again, you need a lawyer who knows the law in district court, who knows what habeas cases can be filed and can't. And at Reeves, we do these types of cases on a regular basis. It's important to have someone who knows what they're doing on that.
So I'm here with partner attorney Flomi Javier Diza. Hello, sir. How are you?
I'm good, right? Pleased to meet you.
All right. Thank you.
I just want to ask you a ton of questions, especially about the K visa. I really want to know, what exactly is the K visa?
A K-1 is a popular visa which is a quick way to bring a fiancé to the United States, usually within 6 months. But if it's not done right, it can delay the case for years.
Did you know? When an application is filed with a government agency, the application has to be decided within a reasonable period of time. Adjudicating an application within a reasonable time period is required by U.S. administrative law. When the agency does not make a timely decision, it may be necessary to file a complaint in U.S. District Court. The legal term for this complaint is Mandamus. It is a lawsuit that seeks an order from a federal court judge requiring immigration officials to adjudicate the case or make a decision. The decision will allow the immigrant to move forward. If the immigration officials grant the petition or application, the individual may be able to move up to lawful permanent residence or citizenship, depending on what benefit was sought. Even if the immigration official issues a denial, the applicant may appeal. However, that appeal can only be filed after the immigration official makes a decision.
I have personally had a number of cases where we were in the immigration court. I've had some where I've been in immigration court. I've won at immigration court. The government has appealed. The Board of Immigration Appeals has upheld the government's appeal. I thought that was wrong, went to the Court of Appeals and won at that point, and they reversed the Board of Immigration Appeals and sent us back to the immigration court to allow the person to get their green card or stay in the United States or get the waiver or get whatever it is that they were seeking. I've also been in district court where I had, quite recently, where I had requested that the government make a decision on a visa petition that was pending. It had been pending for well over a year. I went in, I filed. The government had filed a motion to dismiss. I opposed it, and the judge said that I was right. He denied their motion to dismiss, and he ordered them to make their decision, and we had a decision within probably about 2 weeks. So the clients were able to move forward and, in this case, reunite their children with the United States.
Right.
So it's nice when you can do things like that.
Definitely. Let's say that was, you were my attorney in that case, and let's say that was my case. So how's that? I would be with you as well, going through to the court and everything. So you would be with me there.
In most of the federal court actions, it is just the lawyers who go. In district court, if we're talking about motions or those types of hearings, it's just the lawyers. If, in fact, we're going to go to trial, which may happen on a declaratory relief action, then the client would be there. If, in fact, the client needed to testify, what we would do is, of course, have the client come into the office. We prepare them. We go through all of the questions. We do this numerous times because we all want to make sure that all of our clients are very comfortable once they're in a court proceeding. I assume that everyone's going to be nervous. I assume that this is not something they do all the time. They're not going to do it well if they're not helped, if they're not experienced.
Right.
And so we go through this with them until they're comfortable. And then, of course, with Court of Appeals, if there is oral argument, that again is lawyers only participating. But at any time, if the client wants to come to the hearing to listen, to just observe, they're always welcome. It's their case. It's their life.
Right. Well, Nancy, thank you so much. You've answered so many of my questions today, and I really appreciate it. Thank you for your time.
Thank you.
If you feel that it's taken an unreasonable amount of time to get a decision or even a response from Immigration Service, then it may be time to consult an attorney. Don't go through what Ann Regalo went through. Adequate preparation and sound advice from someone knowledgeable in complex immigration laws and federal courts can help you save a lot of time and hardship.